You're listening to the Valley Current.
Imagine you are playing a game of recess kickball.
Okay, I'm with you.
Right. And the stakes feel incredibly high. You know, the teams are set, the pitcher rolls the ball, and the umpire makes a call that you just absolutely hate.
Like a terrible strike call or something.
Exactly. You are tagged out and it feels entirely unfair. Now, normally in the real world, I mean, you might argue, you might yell a bit.
But you eventually have to just swallow your frustration. Right? Walk back to the dugout and keep playing the game.
Yeah, exactly. You just keep playing. But in this specific bizarre version of kickball, you have been handed this superpower. Once per game, your team has the absolute unquestionable authority to just point a finger at the umpire and fire them on the spot.
Wow. Just fire them.
On the spot. You don't need to ask the league for a replay. You don't need to explain why it was a bad call. You don't even need to justify your decision to the other team. You literally just point and that umpire is legally vaporized from the field.
And just immediately replaced by someone else.
Exactly.
I mean, that sounds like pure playground chaos. It's the kind of completely unbalanced, self-serving rule a kid would invent on the fly just to avoid losing a match.
Yeah,
you know?
totally.
You can just imagine the game grinding to an absolute halt every single time someone gets slightly offended by a strike call.
Pure chaos is exactly what it would be. But here is the wild part, the thing that is almost difficult to wrap your head around. That astonishing level of unchecked unilateral power doesn't just exist on a hypothetical playground. It exists right now.
Right. Baked into the actual real-world legal system.
Yes. Or at least it did in its most chaotic, system-breaking form until very recently. So welcome to today's deep dive. We have a massive, incredibly dense topic on the table today, and we are going to unpack a truly fascinating legal newsletter.
Yeah, the Summer 2026 Special Practice Briefing.
Right. Published by Computer Law Group, LLP. Our mission today is to explore how a 49-year-old a literal cheat code that allowed lawyers in California to simply fire trial judges they didn't like finally got shut down
by a unanimous Supreme Court decision in May 2026.
Exactly.
And, you know, if you were listening to this right now and thinking, well, I am not a California litigator, I've never set foot in a courtroom, why should I care about some obscure rule of civil procedure? You really want to stick around for this one.
Oh, absolutely.
Because this story is not just about dry legal statutes. It is a brilliant and honestly terrifying masterclass in game theory, human psychology, and institutional abuse.
Yeah, it really is.
It perfectly illustrates how a seemingly minor procedural rule built by well-meaning people with good intentions can be quietly, systematically weaponized over decades to bring an entire justice system to its absolute knees.
It's crazy.
It's a story about what happens when the people who are supposed to play by the rules decide it's much more efficient to just break the referee.
Break the referee. Yeah, it really is a system-breaking loophole. But before we can fully grasp how this power was abused to the point of literally breaking the courts, we have to lay the foundation.
Right, the rules of the game.
Exactly. We need to understand how the rules of this particular game were designed to work in the first place, because the design is what created the vulnerability. So let's look at the actual mechanics.
Okay.
According to the briefing, if you are a litigant in California, you essentially have two tools at your disposal to remove a judge from your case. Let's start with the first one, the one that, makes logical sense.
Right. The source text lays this out perfectly by contrasting the two distinct methods, because the contrast is really where the absurdity lies.
Yeah.
The first method is what we can call the hard way. This is governed by California Code of Civil Procedure, Section 170.1.
Okay, 170.1.
Yes. This is a for-cause disqualification.
So this would be the kickball equivalent of proving the umpire actually has money riding on the opposing team.
Precisely. To successfully use Section 170.1, you have to prove an actual tangible conflict of interest. You are required to produce objective, admissible evidence.
Like, you can't just guess.
No, not at all. You have to show the court, for example, that the judge has a direct financial stake in the outcome of your specific case. Or maybe the judge is closely related to one of the parties involved. Or perhaps the judge previously worked as a lawyer on this exact same case before taking the bench.
Oh, I see.
You cannot just walk into the courtroom, look at the judge and say, I have a bad vibe about this person, or I think they looked at me funny.
Right.
You need hard empirical proof, and that proof will be aggressively scrutinized in a formal setting.
Which makes perfect sense. I mean, we want impartial judges, but we also don't want lawyers throwing tantrums every time they get a stern look.
Yes.
But that brings us to tool number 2.
Yes.
And this is where the system just hands over the keys to the castle. If Section 170.1 is the hard way, requiring evidence and hearings, then Section 170.6 is the ultimate get-out-of-jail-free card.
That's a great way to describe it.
This is known as the peremptory challenge. Under this rule, you don't need objective evidence. You don't need to schedule a hearing. You don't need to prove a financial conflict or a familial relationship.
Nothing like that.
Right. All you have to do is file a single-page declaration swearing under oath that you believe the judge is prejudiced against you or your case.
And the consequences of filing that single, incredibly brief piece of paper are absolute, immediate, and utterly devastating to the judge's authority.
Just instant.
Instant. The very moment that declaration is stamped and filed by the clerk, the judge instantly loses all jurisdiction and power over your case. Any orders that judge tries to issue afterward, void.
Wow.
Any rulings they try to make, legally meaningless. They are completely swept off the board. No questions asked, no debate allowed. The case must be instantly transferred to someone else.
Which is just staggering when you stop and think about the traditional power dynamics of a courtroom. I mean, we picture judges as these towering, untouchable figures wrapped in black robes, wielding the full authority of the state. And yet a lawyer can just casually hand over a piece of paper and vaporize that judge's authority in a matter of seconds.
Just like that.
Now, the newsletter points out that the legislature wasn't entirely naive about this. They weren't completely blind to how dangerous this could be.
No, they knew.
Right. They knew this was basically a concealed weapon that could easily be used by lawyers to stall trials, create endless delays, or go judge shopping until they found a friendlier, softer referee for their client.
They did recognize the danger, so they attempted to fence this power in with some very specific guardrails.
Okay, let's unpack this. What were the guardrails?
First, there is a strict numerical limit. You get exactly one peremptory challenge per side, per case.
Okay, so you can't just do it endlessly.
Right, you don't get to just keep firing umpires over and over until you find one whose strike zone you like. You get one bullet in the chamber.
Makes sense.
And second, there are incredibly strict, unforgiving timing windows. The statute outlines a 15-day rule for an all-purpose assignment, which essentially means you have to file your challenge within 15 days of finding out who the judge is going to be for the entirety of your case.
Okay.
Or if you are just dealing with a specific hearing that is noticed 10 or more days out, you have a 105-day rule.
Meaning?
Meaning you have to file the challenge at least 5 days before that hearing takes place.
And the penalty for missing those timing windows isn't just a slap on the wrist, is it?
Oh, it is absolute and final. If you miss that window by a single day, even if you have a great excuse, the right is permanently forfeited for the rest of the case.
Wow.
You cannot play the card late. The legislature wanted to force litigants to make their choice early, before the judge actually started making substantive rulings, to prevent lawyers from, testing the waters, seeing they were losing, and then suddenly pulling the ripcord to get a new judge.
Okay, let's stop and look at this logically, because here is what I don't get. If all it takes is a completely subjective one-page piece of paper to legally strip a judge of their constitutional power, why didn't the architects of this system see that it would inevitably be weaponized?
What?
I mean, even with a strict time limit and a strict one per case limit, if you hand lawyers a giant red button that says, get a different judge, of course they're going to press it.
It seems obvious now, yes.
Right. If they draw a judge who is known for being incredibly tough on white-collar crime and they're defending a CEO, they're going to press the button. If they draw a judge who is notoriously strict on admitting certain types of evidence, they will press it. How could the architects of the legal system not see that human nature would turn this into a tactical game of roulette?
That is the core paradox of this entire law. The architects of the rule actually did try to prevent that tactical roulette, but they relied on a psychological and professional barrier that, in hindsight, turned out to be tragically insufficient.
What was the barrier?
The absolute key to Section 170.6, the linchpin of the whole design, is that the one-page declaration has to be sworn under penalty of perjury.
Oh.
Yes. The legislature, and later the courts that reviewed this, assumed that no licensed attorney would ever casually risk their law license, their professional reputation, and potentially face criminal perjury charges just to swap out a judge for a minor strategic advantage.
So they trusted them.
They fundamentally believed that the solemn gravity of swearing an oath to the court would keep this tool strictly reserved for genuine, deeply held subjective beliefs of actual prejudice.
They thought the honor system would hold up against the sheer competitive cutthroat pressure of high-stakes litigation.
Exactly.
They thought lawyers would say, well, I don't like this judge's rulings, but I can't technically say they are prejudiced, so I won't sign the paper.
Precisely. They assumed the oath was a magical force field. But as the briefing meticulously details, that assumption was deeply, deeply flawed. When the pressure is high enough, and the stakes of a case are millions of dollars or years in prison, the definition of subjective prejudice becomes incredibly elastic in the mind of a zealous advocate.
Which perfectly sets up the disaster that followed, because that flawed assumption that a perjury oath would somehow magically prevent systemic abuse led directly to a nearly 50-year era of legal gridlock.
50 years.
Yeah. The newsletter notes that historians and legal scholars actually refer to this prolonged period as the Solberg blockade. Let's walk through this 49-year forever war, because it didn't just happen overnight. This was a slow-moving train wreck that the justice system watched happen, completely paralyzed.
It really was a generational paralysis. The battle over this get-out-of-jail-free card goes back almost a full century.
Wow, really?
Yeah. The first major skirmish in this war took place back in 1938 in a landmark case called Austin v. Lambert. Back then, the California legislature had passed an early, slightly different version of this rule, and the California Supreme Court of 1938 took one look at it and absolutely struck it down.
Okay, why?
They looked at the mechanics of allowing a lawyer to unilaterally remove a judge and said, this is fundamentally unconstitutional. It is an unwarranted interference with the inherent power of the judicial branch.
So you saw the problem.
They viewed it as a legislative overreach, a tool that allowed litigants to dictate the terms of the court's own internal operations.
So the Supreme Court recognized the danger early on. They killed it dead in 1938. So how on earth did it come back?
Well, the legislature really wanted this mechanism to exist. There is a strong political desire to give citizens an out if they feel a judge is truly biased against them, without forcing them to endure a humiliating, impossible-to-win evidentiary hearing against that very judge.
Sure, that makes sense from a citizen's perspective.
Right. So in 1957, the legislature tried again. They drafted a new version. And this time, they added that crucial perjury oath we just talked about. They made it a sworn declaration.
Oh, okay.
And the following year, in 1958, a case called Johnson v. Superior Court went up to the California Supreme Court to test this new version.
And the court fell for it.
They did. The court looked at the new 1957 version and essentially reasoned, okay, the oath makes all the difference here. Swearing under penalty of perjury is enough of a check against frivolous abuse. We trust the officers of the court. And with that, they officially blessed the statute. The era of the peremptory challenge had officially begun.
But the oath wasn't enough, not even close. And that brings us to the absolute disaster of 1977, the defining moment that locked the courts into a state of helplessness for decades. Solberg v. Superior Court.
What is genuinely fascinating and frustrating about the Solberg decision is how clearly the courts saw the problem unfolding right in front of them, yet felt entirely structurally powerless to stop it.
Break down the Solberg case for us.
Sure. In Solberg, you had a scenario involving a municipal court judge. The local district attorney's office had decided they did not like her. They did not like her rulings. They did not like her judicial philosophy, whatever it was.
Okay.
So the DA's office adopted a blanket policy. They began systematically papering this judge.
Papering, that's the slang for it.
Yes. They were filing these Section 170.6 peremptory challenges over and over and over again in a massive run of similar criminal cases, purely to keep her off the bench.
Just targeting her specifically.
Exactly. They weren't even hiding it. It wasn't a case-by-case evaluation of prejudice. It was an open institutional boycott.
It was an open secret. They were just mass firing a sitting judge because she wasn't playing ball the way they wanted her to.
Exactly. And when this reached the Supreme Court in 1977, the court looked at this mass firing campaign and admitted, in their own written opinion, that this was undeniable judge shopping.
They used those words.
They completely acknowledged the abuse of the system. They thought the DA was using a tool designed for individual prejudice to enact a sweeping political boycott. But, and this is the critical historic moment, they upheld the practice anyway.
Wait. They saw the abuse, They named it as abuse and they just gave it a thumbs up. How did they justify that?
They justified it through a deeply flawed cost-benefit analysis. The court concluded that this kind of blanket abuse, while distasteful, was a relatively inconsequential price to be paid for maintaining a tidy, efficient, and streamlined procedure for removing judges.
An inconsequential price.
They essentially decided that occasionally letting a DA's office bully a judge was better than bogging down the courts with hundreds of messy, complex evidentiary hearings trying to prove actual bias under the old rules. They chose administrative convenience over judicial independence.
An inconsequential price. I want you to remember that phrase because I cannot get over it. Because fast forward a few decades and the price of that blockade became staggering.
Cruelly staggering.
Let's talk about Orange County because the newsletter highlights a horrific case from 2016. It's called People v. Superior Court, but it's widely known in legal circles as the Tejeda case. This is where the Solberg blockade really shows its teeth and where the inconsequential price turns into a constitutional nightmare.
Yes. The Tejeda case is a chilling textbook example of institutional retaliation against a judge who dared to do his job.
Tell us what happened.
So, in Orange County, you had a highly respected jurist named Judge Thomas Goethals. He was presiding over some incredibly heavy, high-stakes criminal matters. And during these proceedings, Judge Goethals made some very tough, very controversial rulings against local law enforcement and the prosecutors.
Okay.
Specifically, after hearing evidence, he found that law enforcement had been operating an illegal underground jailhouse informant network to extract confessions.
Which is a massive scandal on its own.
It is a colossal scandal, but it went further. Furthermore, he found that prosecutors in the district attorney's office had committed serious Brady violations.
Now, we need to pause here because we cannot gloss over what a Brady violation is. If you aren't familiar with criminal law, the term Brady violation comes from a famous Supreme Court case, Brady v. Maryland. It basically means that if the prosecution has any evidence that might prove the defendant is innocent, or even just evidence that makes a witness look less credible, they are constitutionally required to hand that evidence over to the defense attorney. They cannot hide it.
Exactly. The government has all the power, all the police, all the resources. The Brady rule is the great equalizer. It says you cannot cheat to win a conviction. If you have evidence that helps the defense, you must disclose it.
So important.
So when Judge Goethals found that prosecutors had committed Brady violations, he was calling out a massive ethical and constitutional breach. He was saying, you are hiding evidence and you are jeopardizing the integrity of the entire justice system.
So Judge Goethals does exactly what a judge is supposed to do. He holds the powerful accountable. He calls out illegal behavior by the state. He defends the Constitution.
Yes.
And how does the district attorney's office respond to being caught? Do they humbly apologize? Do they appeal his rulings to a higher court to argue he was wrong on the law? Do they fire the prosecutors who hid the evidence?
None of the above.
No. Instead, they weaponized the 1977 Solberg loophole. Over the next 18 months, the Orange County DA's office filed Section 170.6 peremptory challenges against Judge Goethals in 46 out of 49 murder cases assigned to his courtroom.
Let that sink in for a moment. 46 out of 49 murder cases.
Unbelievable.
They effectively exiled a sitting, experienced judge from hearing major felony trials in that county. They built an invisible wall around his courtroom using nothing but one page, sworn affidavits claiming they believed he was prejudiced.
They systematically starved him of his docket as punishment for catching them breaking the rules. And when this obvious, blatant abuse went up to the Court of Appeal in the Tejeda case, the appellate judges were absolutely furious. You can read the opinion, they're seething.
Oh, they were incredibly angry.
But they were structurally trapped. They wrote that their hands were completely tied by that 1977 Solberg decision. Because Solberg had established that blanket papering was an inconsequential price, the appellate court had no legal mechanism to stop the Orange County DA. They had to allow the DA to keep firing Judge Goethals. But they used their written opinion to openly, desperately beg the California Supreme Court to step in, overrule Solberg, and fix this broken rule.
What's fascinating here is that they were essentially sending up a flare from the trenches saying, look at what is happening here. The price is no longer inconsequential. It is actively breaking the independence of the judiciary. If a prosecutor can fire a judge for enforcing the Constitution, we no longer have an independent court system.
So you have to ask yourself, why? Why would a district attorney's office or a public defender's office or a large county council burn so much time, so much administrative paperwork, and so much political goodwill filing these relentless challenges?
Right.
Especially when, by delaying these cases, they are risking witnesses, forgetting details, evidence going stale, and potentially even losing the case in the long run. Why go to war with the courts?
It is a profound question, and the newsletter provides a brilliant analytical lens for understanding the motivation behind this behavior.
Yeah.
Game theory. If you look at it through the lens of human emotion, it looks like a tantrum. But it isn't emotional. It isn't just about lawyers being angry or vindictive. It is pure, calculated economics. To understand the underlying logic of the Solberg blockade, we have to look at the two very different types of players operating within the justice system.
Right. Player type 1 is what the briefing calls the institutional repeat player.
Yes.
These are your district attorneys, your public defenders, your massive county council offices, or even enormous corporate law firms that handle thousands of similar insurance claims. These entities play the litigation game indefinitely. In economic and game theory terms, the newsletter explains that their discount factor, which economists refer to as beta, is very close to 1.
And we need to explain what that actually means in practice.
Please do.
In economics, your discount factor measures how much you value the future compared to the present. A discount factor of 0 means you only care about today. Tomorrow doesn't matter at all. A discount factor near 1 means that tomorrow, next month, and next year matter almost exactly as much to you as what happens today.
Okay, so they are looking long term.
Exactly. Institutional repeat players are playing a long game. An infinite game, really. Because their beta is near 1, an institutional player will happily, willingly lose a single skirmish today. They will gladly eat the cost of a delayed trial. They will happily waste hundreds of staff hours filing paperwork. And they will even risk losing a specific case if doing so permanently clears a demanding, strict, or independent judge off the bench for the next decade.
Because removing that judge tilts the playing field for the next 1,000 cases.
Exactly. To them, the short-term loss of time or money today is just a necessary capital investment in a much more favorable environment tomorrow. They calculate that if they can bully a tough judge out of the rotation, their conviction rates or their settlement payouts will improve by 5% across all future cases. The math dictates their strategy.
So what does this all mean for the other type of player? Because then you have player type 2, the one-shot litigant. This is your single criminal defendant waiting in a jail cell, a conservatee fighting for their autonomy, or a mom-and-pop business plaintiff in a single breach of contract case. They are only playing the justice system game once in their entire lives.
Right, they just want it over with.
Exactly. Their beta, their discount factor, is mathematically near 0. Only this specific case matters to them. They don't care about the judicial rotation in 2030.
And because they only care about resolving their one specific issue right now, they cannot afford to invest in reshaping the courthouse. They just need a fair trial as quickly as possible so they can get on with their lives.
Let me try out an analogy here to make this really concrete.
Go for it.
Think about this dynamic like a massive multi-billion-dollar corporate landlord going up against a single-family renter in a municipal housing court. The corporate landlord has a beta of 1. They own 10,000 apartment units across the city. They can afford to bleed hundreds of thousands of dollars on a single, prolonged, deeply inefficient lawsuit against one solitary tenant if they believe that winning that lawsuit will set a legal precedent that permanently changes the city's rent control laws in their favor.
Right. The precedent is what matters.
Exactly. They will take the financial hit today to own the market tomorrow. But the renter has a beta of 0. The renter doesn't care about zoning precedents for the next decade. The renter just wants their leaky roof fixed today before the winter rains come. The tragedy of the legal system under Section 170.6 is that the repeat player isn't just trying to win the game on the field. They are systematically trying to buy the stadium.
That is a perfect, striking analogy. And the true tragedy, as the newsletter astutely points out, is who actually absorbs the cost of this institutional strategy.
Who pays the price?
When a DA or a public defender files 50 challenges against a judge, the institutional players don't suffer. They externalize all the collateral damage of those delays on to the one-shot litigants.
Uh-huh.
The entire court system bogs down. Cases have to be meticulously reassigned, trial dates get scrambled, pushing everything back by months or years, and the single defendant sitting in pretrial detention or the single plaintiff waiting for a life-saving settlement is the one left rotting in legal limbo while the giants play their Game of Thrones.
Wow. And it goes even deeper than just logistical delays and clogged dockets, doesn't it? Because the brief touches on a much darker implication of this game theory.
It absolutely does. If we step back and connect this to the bigger picture of how a democracy is supposed to function, this was fundamentally a constitutional threat.
How?
The briefing makes it explicitly clear. This was a severe separation of powers problem, dressed up as routine, boring administrative filing. By using these peremptory challenges systematically to exile judges like Thomas Goethals, lawyers from the executive branch like a DA's office were effectively seizing the judicial branch's own power to assign judges.
Oh, I see.
They were dictating how an independent, co-equal branch of government operated. They were choosing their own referees.
Which brings us finally to the breaking point, the absolute tipping point, the moment when the math of this institutional abuse got so outrageous, so undeniably destructive, that the California Supreme Court could no longer hide behind the 1977 Solberg decision and look away. We are talking about early 2026 in San Joaquin County.
Yes, the landmark case of JOV Superior Court. And to understand the catalyst here, we need to look at Judge Erin E. Guy Castillo.
Okay, tell us about her.
She was presiding over cases in San Joaquin County, specifically handling a specialized docket. During a proceeding, she admonished an attorney from the county counsel's office for improper conduct.
Again, a judge simply doing her job, policing the decorum and ethics of her courtroom.
Precisely. But in response to that single routine admonishment, the county counsel's office did exactly what the Orange County DA had done a decade earlier. They adopted a blanket institutional policy against her.
Oh.
They decided they would unilaterally disqualify Judge Castillo from all conservatorship matters handled by their office.
Now, before we get to the sheer volume of strikes they filed, we need to understand what Judge Castillo was actually doing, because the context makes this so much worse.
What is a conservatorship? Why are these cases so incredibly sensitive?
It's vital context. Imagine an adult who, due to severe mental illness, advanced dementia, or a catastrophic cognitive decline, can no longer feed themselves, manage their money, or make basic medical decisions.
Okay.
A conservatorship is a legal process where the court steps in, strips that vulnerable adult of their fundamental legal rights, and hands those rights over to someone else, a conservator, to manage their life.
Wow, that's huge. It is arguably the most drastic, intrusive power a civil court has over a citizen. It involves life, death, money, and fundamental human autonomy.
Yeah.
Because the stakes are so high and the law is so incredibly complex, you desperately need a highly trained, specialized, experienced judge handling these specific cases. You cannot just hand a complex mental health conservatorship to a judge who usually handles traffic tickets.
Okay, keeping that massive responsibility in mind, let's look at the retaliation. I had to read this next part in the briefing 3 times to make sure I wasn't hallucinating.
That's pretty shocking.
The county counsel's office didn't just file 5 or 10 challenges because they were mad at Judge Castillo. According to the record, they filed an estimated 325 peremptory challenges in under 4 months.
325. In less than 120 days.
Think about the pure grinding logistics of that, just the reams of paper. Imagine being a court clerk and every single day the county counsel walks in and drops 3 more sworn affidavits on your desk.
It's completely overwhelming.
The administrative burden on the clerks, the constant rerouting of files, the frantic phone calls trying to find another judge who is qualified to hear complex conservatorship law. It is industrial scale, weaponized judge shopping.
Yes.
And it had a devastating immediate effect. The presiding judge of that court, the person in charge of managing the schedule, had absolutely no choice. The docket was completely paralyzed, so they had to pull Judge Castillo out of the specialized mental health and conservatorship department entirely.
Just exactly what they wanted.
Right. They reassigned this highly trained expert to handle traffic court, misdemeanors, and small claims. The county council successfully legally bullied a specialized judge off her own docket.
But this time the narrative shifted. Someone finally fought back. A conservatee, a vulnerable individual caught in this system, identified in the court records only as J.O., challenged this massive papering campaign.
Good for them.
J.O. and their legal team argued that this was not just routine procedure anymore. This was a coordinated, bad faith attack on judicial independence that was actively harming the vulnerable citizens the court was supposed to protect.
Did the lower courts listen?
Well, initially, as you might expect, the lower courts turned J.O. away. Why? Because they were still legally in handcuffs. They were bound by that 1977 Solberg decision.
Oh, the inconsequential price thing?
Yes. They basically looked at J.O. and said, we agree this is a terrible situation. We agree the county council is abusing the system, but the Supreme Court has declared this an inconsequential price. We cannot help you.
But J.O. didn't give up. They appealed it all the way to the top. And on May 28, 2026, the California Supreme Court finally woke up and struck back. Justice Joshua P. Groban authored the opinion, and it wasn't a narrow, split decision.
No, it was a 9-0 unanimous resounding vote. They formally overruled Solberg. It was a monumental tectonic shift in California law. Justice Groban, in his opinion, pointed out a very pragmatic reality. The trial courts of 2026 look absolutely nothing like the courts of 1977.
Right. Things change.
The Solberg court lived in a different era. Today's superior courts are incredibly busy. They are facing massive backlogs. They are chronically under-resourced. And crucially, they rely heavily on specialized dockets to survive. You have complex civil litigation departments, specialized mental health courts, dedicated employment law courts. These departments are staffed by judges with highly particular esoteric training.
You can't just swap them out like interchangeable Lego bricks.
Exactly. Blanket papering against a specialized judge doesn't just delay one specific trial. It can literally hollow out an entire specialty bench. A county might only have 1 or 2 judges trained to handle the nuances of complex conservatorship law. If an institutional player like the county council boycotts them, the whole system collapses.
There is nowhere else for those cases to go.
Right. Justice Groban recognized that the inconsequential price had become an existential threat to the court's ability to function.
Okay, so the Supreme Court finally ends the 49-year Solberg blockade. They strike down the blanket abuse. But, and this is a really important, tricky nuance in the newsletter, they didn't delete the law.
No, they didn't.
They didn't abolish the statute itself. Section 170.6 still exists on the books. Litigants still have the get-out-of-jail-free card in their pocket, which raises a massive, immediate question. How on earth do you allow lawyers to keep using this free pass without letting them abuse it again?
It's a tricky balance.
Yeah. Who decides if a lawyer is lying about their subjective belief of prejudice? How do you keep the card in the game but stop the repeat players from printing their own counterfeit currency?
It's a brilliant question, and the Supreme Court solution was to build a brand new procedural test from scratch. And to do it, they borrowed a framework from a completely different, highly scrutinized area of constitutional law, the Batson framework.
Right, Batson. I mean, anyone who listens to true crime or follows high-profile trials has probably heard of Batson. It's usually used in jury selection, right?
Correct.
It comes from the case Batson v. Kentucky, and it's designed to stop lawyers from using their peremptory strikes to kick jurors off a panel based purely on race or gender.
Correct. The Batson test was originally designed to sniff out hidden, unconstitutional, discriminatory motives behind a lawyer's peremptory strike of a juror. The Supreme Court, in the J.O. case, looked at that tool and brilliantly adapted its core logic to the problem of judge shopping.
Okay, how does it work?
They created a 4-phase burden-shifting test to separate genuine challenges from bad faith institutional boycotts.
This is where the mechanics get really fascinating. Let's walk through this new playbook phase by phase to see how it actually works in a courtroom today. Phase 1 is what we can call the strike.
Yes, the strike.
This is where the challenging party files the exact same standard, sworn one-page declaration that they believe the judge is prejudiced. They hand it to the clerk. And if nobody says anything, what happens?
Well, if the opposing party remains silent and nobody objects, the challenge is granted automatically, just like the old days. The judge is off the case. This is a crucial point. The ordinary, single, good faith strike used by a one-shot litigant is completely untouched. It is still the norm. The Supreme Court didn't want to kill the tool entirely.
But now we have phase 2, the objection. And this is the absolute game changer.
Yes. In phase 2, the opposing party, or potentially even the court itself, can step in, raise a flag, and say, hold on a minute.
Right.
They have the opportunity to make what the law calls a prima facie showing of a pattern. meaning they have to present enough preliminary evidence on the surface to show that the striking party isn't just making a one-off decision, but is engaging in a systematic pattern of repeated strikes against this one specific judge, or perhaps a whole category of judges.
So they have to show the court that this looks like an institutional boycott. And if they can successfully show that pattern, we move to phase 3, the neutral inquiry. And as you read this section in the briefing, you really start to visualize how incredibly dramatic this is going to be in practice.
Yeah, very dramatic.
Because the challenged judge, the one who was just accused of being prejudiced, doesn't hear this objection. That would be a conflict of interest. Instead, a different neutral judge from down the hall has to come in and hold a special hearing. For the first time in nearly 50 years, the California courts are legally allowed to look behind the curtain of that sworn affidavit.
If we connect this to the bigger picture, the historical significance of this is that the sacred barrier of the perjury oath has finally been pierced.
Wow, yeah.
For half a century, the courts blindly trusted the lawyer's signature. Now the court is saying, we no longer blindly trust your oath. We're going to examine your track record. We're going to look at your data.
But I want you to put yourself in the shoes of a litigator for a second and think about how excruciatingly awkward this phase 3 hearing must be. Just imagine the courtroom drama.
It would be incredibly tense.
You are a senior litigator. You just filed a piece of paper swearing under oath that Judge A is horribly biased against your client. Now you are standing at a podium in front of Judge B, and Judge B is staring down at you over their glasses, holding a formal hearing to decide whether you are lying to the court about your subjective feelings regarding their colleague, Judge A.
Yeah, that's rough.
The tension in that room must be suffocating.
It is intensely awkward, and the professional stakes for the lawyer in that moment are astronomical.
Which brings us to the climax of the process, phase 4, the proffer.
The proffer. What happens here?
During this high-tension hearing, the burden of proof suddenly shifts back onto the shoulders of the lawyer who filed the strike in the first place. They must now stand up and provide an actual, non-pretextual, case-specific reason for why they truly believe the judge is biased in this specific case.
So they can't just be vague.
No, they cannot just shrug and say, it's my office's policy, or we don't like her general vibe. They have to articulate a real, tangible, good-faith reason that applies to the facts of the case before them. And what happens when they give their reason? What are the possible outcomes?
It's binary. If the neutral judge listens to the explanation, evaluates it, and decides the reason is genuine, credible, and given in good faith, then the challenge is granted, and the original judge is disqualified. The system worked.
Okay, and the other outcome?
But if the neutral judge decides the lawyer's explanation is weak, contradictory, or simply a pretext, a fabricated cover story designed to hide an institutional judge shopping campaign, the motion is forcefully denied, the strike is thrown out, and the case stays exactly where it is with the original judge.
And that lawyer now has to go back and try their case in front of the very judge they just unsuccessfully tried to fire, knowing the judge knows they just lied to get rid of them. Talk about a hostile work environment.
To say the least, it completely changes the risk calculus for any lawyer considering a bad faith strike. Now, you would think that a 9-0 Supreme Court ruling overhauling the system would be the end of the story. The Supreme Court decisively fixed the trial-level institutional abuse. But the newsletter dives even deeper, detailing how this peremptory challenge card actually possesses a strange sort of immortality.
It really does. It gets a second life.
Right. It reincarnates when a case goes up on appeal and eventually comes back down to the trial court.
Yes. The briefing highlights a fascinating subsection of the law, section 170.6A2. This specific provision deals with what happens when cases are remanded.
Let's establish the scenario for everyone.
Let's say you go through a grueling trial and you lose. The trial judge rules against you. You firmly believe the judge made a legal error, so you appeal the decision to a higher appellate court.
Okay.
The appellate judges review the transcripts, agree with you, reverse the trial judge's decision, and send the case remanded back down to the trial court to be fixed. And what happens if the luck of the draw means your case gets handed right back to the exact same trial judge who originally ruled against you and who just got publicly reversed because of your appeal?
Well, under this specific rule, if that happens, the winning party on appeal is granted a fresh, brand new peremptory challenge. They can instantly fire that judge even if they had already used their one allotted challenge years earlier at the very beginning of the case. They get a bonus strike.
I absolutely love the reasoning behind this rule. The newsletter explains that this provision was added by the legislature in 1985 to guard against a psychological phenomenon known as appellate pique.
Appellate pique.
To me, this is just fascinating. The formal, rigid, highly technical California legal code literally had to write a statutory rule to protect average citizens from a judge's bruised ego. It is a stunning, codified acknowledgement of pure human frailty.
He really is.
The law is essentially whispering to the litigant, hey, you just publicly embarrassed this judge by getting their homework aggressively corrected by the appellate court. They might be a little cranky about it. They might hold a grudge. So we are giving you a free pass to get a new referee.
It is a profoundly pragmatic rule. Judges, despite the robes and the honorifics, are human beings. No professional likes having their mistakes broadcasted and corrected in public, especially by a higher authority.
Right.
The legislature recognized that subconscious bias appellate pique was a real risk to a fair retrial. However, just like with the trial-level strikes, litigants immediately recognized a loophole and tried to stretch this rule to its absolute breaking point.
Shocker.
Lawyers started aggressively trying to use this post-appeal bonus challenge to judge shop every single time a case was remanded, even for the most minor technical clerical corrections.
Right, lawyers were treating it like a cheat code. Oh, the appellate court affirmed the entire multi-million-dollar verdict, but said you miscalculated the interest rate by 0.5%. Boom, new judge. I'm firing you before you can fix the math.
Exactly. The abuse was threatening to derail the post-appeal process, so the courts had to step in once again and draw a very strict, bright-line boundary. They ruled that you only get this fresh challenge if the remand from the appellate court constitutes a genuine new trial.
And the briefing gives some really clear, incredibly helpful examples of what counts and what doesn't count as a new trial under this rule. Let's look at the edge cases to see where the line is drawn.
Good idea.
On the allowed side, you obviously have full retrials. The newsletter cites the Stevens case here. If the appellate court says the original trial was fundamentally flawed, throw out the verdict, do the whole trial over from scratch, yes, absolutely, you get a new challenge. You are re-examining contested facts and litigating the law all over again.
You also get the challenge for what we call limited evidentiary hearings. The briefing highlights the Steggs case to illustrate this.
What happened there?
In Steggs, the appellate court ruled that if the remand requires the trial judge to hold a new trial-like hearing to resolve specific facts that are still actively contested between the parties, that functionally counts as a new trial. The judge is going to have to weigh evidence and make subjective determinations of credibility again, so the risk of appellate pique is high. You can use your challenge.
But then you have the denied column, where the courts shut the lawyers down. The newsletter cites a 2003 case called Peremptory. In that case, a criminal defendant won an appeal, and the case was sent back down strictly for resentencing. No new facts were being introduced.
Right, the conviction stood.
Exactly. No new liability was being debated. The judge just had to adjust the sentence based on the appellate court's instructions. The ruling, denied. That is not a new trial.
Yeah.
You don't get to fire the judge.
The exact same logic applied in a 2006 civil case, First Federal Bank. In that scenario, the case was remanded merely to fix the exact dollar amount of attorney's fees awarded to the winning side.
Just adjusting the numbers.
Yeah. The question of who was liable was completely settled. The question of who won was settled. It was just a math problem at that point. The court ruled that fixing a fee calculation is not a new trial. Challenge denied.
Makes sense.
And certainly, any specific ministerial orders, like recalculating a specific interest rate or simply entering a specific order that the appellate court explicitly dictated word for word, those do not trigger a fresh challenge. If the trial judge has no judicial discretion left, if they're just acting as a rubber stamp for the appellate court, there's no room for them to be biased against you. So you don't need a peremptory challenge to protect yourself.
Okay, so if we take a massive step back and look at the whole board, the courts have successfully walled off the post-appeal abuse regarding remands, and now, with the monumental 2026 JO decision, they have finally walled off the trial-level institutional abuse that plagued the system for 49 years.
Yes.
The landscape of California civil procedure has literally changed overnight. A massive earthquake has hit the legal profession. Which brings us to the final and arguably most important section of our deep dive, the future shock.
The future shock.
Because what happens tomorrow morning when thousands of lawyers walk into courtrooms across the state and realize the old tricks don't work anymore?
That is where the Computer Law Group newsletter really shines. It doesn't just report the news. It leaves us with a brilliant, deeply provocative set of unanswered questions for reflection. Because whenever you take a sledgehammer to the rules of a complex, interconnected system like the judiciary, you inevitably create massive ripple effects that no one can entirely predict.
Let's run through these questions because they represent the immediate frontier of litigation strategy. First up, the threshold problem. The new Supreme Court rule says you have to show a pattern of abuse to trigger a Phase 3 hearing. But what actually constitutes a legally actionable pattern? Is it 10 strikes against a single judge? Is it 50 strikes? Does it have to be a specific percentage of a judge's total caseload?
It is the ultimate gray area. I mean, the J.O. case dealt with 325 strikes. That is obvious, undeniable abuse. But what happens next week when a public defender's office files 15 strikes over a 6-month period? Is that just a string of coincidences, or is that a pattern?
Who decides?
Exactly. The trial courts are going to have to invent the mathematical threshold on the fly, case by case, without any clear guidance from the Supreme Court. It is going to be incredibly messy.
Then there is the perjury exposure, and honestly, this one is explosive.
This raises an important question, perhaps the single most critical ethical question posed in the entire brief. Think back to Phase 4 of the new test. Let's say a neutral judge holds a hearing, listens to a lawyer's explanation for why they struck Judge A, and officially rules that the lawyer's stated reason was a pretext. The judge is essentially ruling on the official record that the lawyer lied to the court to hide an institutional boycott.
Right.
What happens next? That lawyer signed a declaration under penalty of perjury. Does the neutral judge now have an affirmative ethical obligation to report that lawyer to the state bar for committing perjury?
Wow. I want you to really visualize the panic this is causing. Think about the ethical time bomb currently sitting on the desks of thousands of lawyers across California. For decades, attorneys casually signed these perjury oaths as standard operating procedure. It was just a form you filled out.
Yeah, every bit of it.
Suddenly, overnight, that signature has jagged, terrifying teeth. If you get caught papering a judge, you aren't just losing your motion. You could literally lose your license to practice law. The state bar could open an investigation. Your career could be over.
Exactly. The chilling effect on lawyers will be immediate and profound. And beyond the individual lawyers, there is the massive systemic impact on the courts themselves. The briefing calls this the docket ripple.
The docket ripple.
The entire stated purpose of the J.O. decision was to save court time by stopping the endless abusive reassignment of cases that paralyzed judges like Thomas Gotholz and Aaron Guy Castillo. But now, to enforce this new rule, courts have to hold secondary mini-trials, those Phase 3 hearings, just to decide if the lawyer is allowed to fire the first judge.
Which means you are using 2 judges to handle a dispute about 1 judge.
Precisely. How much worse will court delays get in the short term, as everyone aggressively litigates the new rule? Every time a lawyer tries to strike a judge, the opposing counsel is going to scream, "Pattern," just to force a Phase 3 hearing and bleed the clock. The cure might temporarily look just as chaotic as the disease.
And you know, the institutional repeat players aren't just going to give up and play nice. They have too much on the line. The briefing asks about the pivot. Will high beta repeat players, the DA offices, the massive corporate defense firms just get sneakier?
Probably.
Right. Instead of foolishly filing a blanket boycott and papering 1 judge 300 times in 4 months, will they use quieter, more sophisticated substitution patterns? Will they hold a secret meeting and decide to only strike the target judge every 3rd case, or only on Tuesdays? Just enough to tilt the odds but fly under the radar of what a court might define as a pattern.
They are highly intelligent, strategic, well-resourced actors. They will absolutely probe the new boundaries to see where the electric fences are now located, which leads directly to the final, perhaps most economically significant question the briefing poses, aimed squarely at the business world. Corporate exposure.
This is huge for general counsels listening right now. This is where the obscure civil procedure hits the corporate bottom line.
It absolutely is. Let's say you are the general counsel of a Fortune 500 corporation. Your company gets sued in a jurisdiction you aren't familiar with, so you hire a prestigious local law firm to defend you. What is your fundamental duty to deeply vet the historical behavior of that local counsel before you sign the retainer?
Oh, I see where this is going.
If you unknowingly hire a local law firm that has a secret known history of aggressively papering a specific judge in that county, and that firm tries to strike that judge in your company's case, and the strike gets challenged and denied.
Your company is now trapped.
Yes. You are stuck litigating a high-stakes, multi-million-dollar case in front of a judge who knows for a fact that your lawyers just tried to fire them on false pretenses.
Yeah.
The local firm's toxic reputation just became your client's massive financial liability.
The judge is going to look at your corporate defense team and think, these people just lied to my face to get out of my courtroom. Like, good luck getting a favorable ruling on a close evidentiary call after that. It is a totally new, terrifying landscape of risk for corporate clients. This entire briefing, from the history to the game theory to the future shock, just shows how deeply, invisibly interconnected every single piece of paper in a courthouse really is. One form changes, and the whole ecosystem shudders.
It is a profound reminder that procedural rules are never just procedural. They are not boring. They are the invisible scaffolding of power in our society. When you understand the procedure, you understand who really controls the game.
Which leaves us with a final thought to mull over today as we wrap up this deep dive. For half a century, the California justice system accepted a known, open lie. Every judge, every lawyer, every clerk knew that attorneys were constantly striking judges for tactical game theory reasons, not out of a genuine subjective belief of true prejudice. But the entire system accepted that polite fiction because it made the paperwork easier. It kept the massive grinding machinery of the courts moving forward. It was an inconsequential price.
Until it wasn't.
Right. But now, with JOV Superior Court, the highest court in the state has finally been forced to look behind the curtain of that specific legal fiction and tear it down. So as you go about your day, think about this. What other polite fictions are quietly holding up our overburdened justice system right now? What other open secrets are we all just accepting because it's easier than fixing them? And which one is ripe to be disrupted next?
Fascinating and necessary question to ask.
Led by Jack Russo, Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at computerlaw.com and his team at www.computerlaw.com, where the newsletter we referred to is published in detail and readily available, commitment-free with no paywalls or other charges.
Tune in next time on The Valley Current.